Dear students, hello everyone. Today we will be studying Chapter 10, Section 2, the signing of contracts. During the negotiation of transactions, when one party's valid offer is effectively accepted by the other party, the transaction is considered established, and the buyer and seller form a contractual relationship. The correspondence exchanged during the transaction negotiation serves as the written evidence of the contract. However, according to international trade practices and Chinese legal regulations, the parties should also sign a written contract with a certain format to further clarify their rights and obligations and to facilitate the fulfillment of their respective duties. 1. The significance of signing a written contract. Evidence of contract formation. According to legal requirements, every contract must be able to be proven, which includes both testimonial and physical evidence. During correspondence negotiations, the letters, telexes, and the telegrams exchanged between the parties can serve as written proof. However, contracts reached through oral negotiations are difficult to substantiate unless there is audio or video recording. Therefore, contracts reached through oral negotiations, if not confirmed through a certain written form, may become unenforceable due to lack of proof, rendering them invalid in the eyes of the law. By signing a written contract, the existence of the contract can be proven through its written form. If disputes arise between the parties regarding the content of the contract, they can refer to the specific provisions outlined in the contract and seek legal protection. Conditions for the effectiveness of a contract. The convention and the laws of most countries stipulate that as long as acceptance takes effect, the contract is deemed to be established. However, if during the transaction negotiation one party has declared subject to the signing of a written contract, or if the law requires that a written contract must be signed, then the written contract is a necessary condition for the establishment of the contract. According to the laws of our country, when the parties use a contract document, including a confirmation form, to enter into a contract, the contract is established at the time when both parties sign or affix their seals. If the signing or sealing does not occur at the same time, the contract is established when the last party signs or affixes their seal. Additionally, for contracts that require review and approval by the government of one or both parties' countries, a written contract with a certain format must be signed. The basis for contract performance. The fulfillment of a contract involves many internal and external departments and personnel of both the buyer and the seller. If it's an oral contract, it will create significant difficulties and inconveniences for the performance of many departments and personnel. Even transactions reached through means such as letters, telegrams, or telexes, if the conditions negotiated in all the correspondence are not summarized into a unified written contract, it will be extremely difficult to fulfill. Therefore, whether the transaction is reached through oral or written negotiation, a written contract is absolutely necessary for performance. 2. Conditions for a valid and established contract. After the buyer and the seller have reached an agreement on all the terms of the transaction, it does not necessarily mean that the contract is definitely valid, according to the contract laws of various countries. A contract with legal binding force, in addition to the arrangement reached by the seller and the buyer on the terms of the transaction through offer and acceptance, must also meet the following valid conditions. The parties must possess the capacity to enter into a contract. The laws of various countries all stipulate that both natural persons and legal entities with capacity for action have the ability to enter into a contract. According to general legal provisions, a natural person with capacity for action refers to an adult with a sound mind. However, the age at which one is considered an adult vary among countries. Japan and Switzerland specify that those who are 20 years old are considered adults. Mexico specifies that those who are 23 years old are considered adults. The exercise of capacity for action by legal entities must be carried out by their legal representatives or authorized representatives. A legal entity must enter into contracts through its agents. Within the scope of the legal entity's business operations, contracts that exceed authority do not have legal validity. The contract must have consideration or cause. Consideration refers to the price that the parties pay in order to obtain the benefits of the contract. That is, mutual performance, a term of contract in the Anglo-American legal system. Cause refers to the direct objective that the parties pursue when entering into a contract. A requirement for the formation of a contract in the civil law system. According to general legal provisions, when it has consideration or cause, the contract is only valid in the eyes of the law. A contract without consideration or cause is not protected by the law. 3. The content of the contract must be legal. The content of the contract must be legal, including not violating the law, not violating public order or public policy, and not violating good morals or ethics in 3 aspects. 4. The contract must conform to the form prescribed by law in most countries of the world. The law does not have special requirements for the form of trade contracts. That is, whether in oral form, written form, or expressed through actions, it is all permissible. Left to the discretion of the trade parties, that is, the principle of informality. Additionally, in some countries, the law stipulates that trade contracts exceeding a certain amount must be concluded in written form. For example, the Uniform Commercial Code in the United States specifies that any trade contract exceeding $500, unless otherwise provided, must be in written form. 5. The expression of intent of the contract parties must be genuine. Contract laws in various countries all hold that the expression of intent by the parties to a trade contract must be genuine and without defects. Any expression of intent made under the influence of fraud or coercion is false and not genuine, and therefore trade contracts signed under such circumstances are invalid. Fraud refers to a deliberate act intended to cause another person to make an error. All legal systems consider that any contract entered into as a result of fraud allows the deceived party to rescind the contract, declare it null and void, and claim compensation for losses. Coercion refers to a deliberate act intended to induce fear in another person. For example, one party may use their substantial financial and material resources as well as advanced technology and management experience to threaten or coerce the other party psychologically, forcing them to accept unfair trading conditions. 3. Important considerations when signing a contract. 1. Strive to sign at our location. For significant or high-value transactions, after reaching an agreement, a formal contract signing ceremony should be arranged, and we should strive to sign at our own location. This is because the signing location often determines the applicable law in resolving contract disputes. According to the general principles of international law, if a contract does not specify which country's law to apply in case of a dispute, once a dispute arises, the court or arbitral tribunal may render a judgment or arbitration based on the law of the country where the contract was concluded. If a signing ceremony is not held in person, but rather a contract is signed sequentially by mail, it should also be stipulated in the contract that the signing location is at one's own place of residence, or that the contract is to be governed by the laws of one's own country. Selecting an appropriate signing method. In practice of international trade, it is often difficult for contracts to be signed in person by both parties, and instead, they are typically made effective through sequential signing via postal mail. To prevent the other party from altering the contract after our side has already signed it, we should promptly and carefully review it, to ensure that the content has not been altered or added to in any way. If there are any changes, we should immediately inform the other party that we cannot accept the modifications to the contract. Alternatively, based on the archived copy, raise objections with the other party. Thorough review. Before formally signing the contract, it should be carefully reviewed from 3 aspects. Firstly, check whether the contract text clauses align with the agreed-upon transaction terms. Secondly, ensure that the various clauses within the contract are consistent and harmonious with each other. Thirdly, confirm that all necessary approvals, project approvals, licenses, etc. are complete and that the contract content matches the approved content. The review of the contract must be done in comparison with the original correspondence and the negotiation records. Confirmation of the signatory's identity and legal qualifications. For an international trade contract, it must be signed by the legal representative of the enterprise or their authorized representative, so it can become effective. To ensure that the representative signing the international trade contract has the legal qualifications, the legal representative should be requested to present their identification certificate. When the contract is signed by an authorized representative of a legal entity, not only should an identification certificate be presented, but also a power of attorney should be provided to confirm whether the individual is a legitimate agent and whether they have exceeded their authority.